Good day and welcome to another edition of the Land and Property Focus, which is a show that is to help us all learn, have a discussion and be empowered when it comes to land and property issues in Ghana. My name is Nana Utu-Texan. The topic for today is Stool and Family Lands Explained, and I tell you why that is important. Since 1992, the predominant chunk of land that is available for sale in Ghana have been family lands or stool lands. Since the Land Act 2020, there have been further changes, and therefore it is important for anybody who is interested in buying land, or perhaps anybody who owns land at this point, actually to have an understanding of what these rules are, what the opportunities are, some of the pitfalls, and how to actually manage these lands going forward. I have a guest with me today who is well versed in this topic, and would help us navigate our way through. Please, if you're watching on Facebook, do like the Facebook page as well as share with your friends. Let's keep the gospel, as it were, wide, and let other people also share in this message which we're sharing on this platform. And if you're also watching on YouTube, please do subscribe and do share us as well amongst your contacts. We now do have a WhatsApp number which would help you if you do want to have a conversation with either myself or any of my guests, or if you do want to ask questions and you're not on either Facebook or YouTube. And the number is plus 233 500 600 73. I repeat, the number is plus 233 5000 600 73. So as is customary with the show, I would move on to the law session. So just to tie in with today's conversation, I have chosen the definition for stool land and family land. And I tell you why perhaps this is also very important. I actually had a query yesterday from somebody who's interested in land in Ghana, and the question was stool ? And I could understand that different people see stool in different meanings to stool. So this is the statutory definition for stool land and family land, which is what we're going to discuss today. And my guest today would actually break it down for us to actually understand it. So I would move on now to bring on my guest so that we can start the show going. My guest for today, as you may have seen on the flyers, is Mr. Stephen Badu. Mr. Badu actually trained as a land economist before going on to qualify as a lawyer. And I make a point to get these lawyers because they do understand land and property differently than what I would call the bog standard lawyer. So Mr. Badu is in private practice in Accra and specializes in land and property. Welcome, Mr. Badu, to the show.
Thank you.
So I obviously deliberately stopped myself from reading the statutory provision or definitions for stool land and family land, because even for myself, it appeared a mouthful and I didn't want to confuse myself reading it. And I guess you would understand that the average person, the man on the Golukwati bus or the woman who sells in the Kotokraba market would struggle to understand, perhaps as well as myself, some of these definitions as has been put in the law. Can you please explain to us what family land is and what stool land is?
Okay, thank you, Nana. Family land basically is land owned by a group who trace their ancestry to a common lineage. And the stool land is land owned by people who owe allegiance to a particular stool. Okay. Now, just like any governance structure system, they cannot all manage the land at the same time. So they select or elect someone, in this case a chief or a head of family, to be the one to manage it on their behalf and manage it for the benefit of the members of the stool or the family. Now, it's quite instructive that Article 36, Clause 8 of the Constitution 1992, and then Section 9, Subsection 2 of the Land Act says that these chiefs or family heads are fiduciaries or trustees charged with the management of the land entrusted to them for the benefit of the members or subjects of the stool or family. That is quite instructive. So what it means is the land does not belong to them. It belongs to the people they lead. So basically, that is what the stool land and family lands are. And then, there are interests in these lands. It could be allodial. I don't want to go into the technicalities of that, but basically that is it.
Thank you very much for that exposition. I guess so now when we do meet any of these family heads or chiefs who are, prancing about and making us feel that they own the land, absolutely. I think it's a good initial education point for everybody to know that they actually don't hold the power alone because they are acting on behalf of the family, and perhaps the structure then is very important as to who can even give you land or lease land to you. So what do you look out for when you're buying land from either a family or from a stool? What are the requirements?
It is very important to be very cautious when you're buying land from the stool or from the family. The first thing that you need to look out for is to conduct a search. Don't forget that the Act requires that stool land, family land must be registered with the Lands Commission. All right. So the first thing to do is to do a search. I wouldn't say it is foolproof, but go to the Lands Commission and then do a search and find out to determine that you are dealing with the right family or stool. That's the first point. After you satisfy yourself with that, the next is to make sure that whilst you are purchasing this land from either the stool or the family, like I said in the definition, it is not only the chief or the family head, it's also about the entire family. So the law requires that the principals of the stool or elders of the family must give their consent and concurrence before the transaction can be valid. So it's important to make sure that once you are purchasing the land, you get the consent and concurrence of the principals or elders of the stool or the family. And that's very key. You need to look out for that.
Okay. So I guess my question then is, when I go to Afienya to buy land and I meet Togbi Sasaku, who says he owns the land there, how do I know who he has to confer with or who has to sign the agreement? And, I'm a man just off the street interested in buying land. How do I know that? I know you've mentioned the issue of the searches. And I've said on this show before that obviously the searches are as good as what information the Lands Commission has. But I understand the general advantage that, especially when there's dispute, it would be seen that at least you have made the effort to check to see if anybody owns it or to verify the people you're transacting with. So I do understand it. But primarily, how do I know if I go and buy land, whether, for instance, in a particular family or for a particular stool or skin, 4 or 5 people are the people who are to sign and not 2 or 3 people, and indeed what their identities are?
Well, presently, it will be very difficult. You may do your due diligence, to find out as to who the principals or elders of the stool or family are, all right? But the most important thing is the lease document that will be given to you or you'll be signing with the stool or the family would have to have recitals that indicate that the transaction or the conveyancing is being done with the consent and concurrence of the principals and elders of the stool or the family. And the law also requires that these people would have to be part of those who execute the lease. So meaning their names must be indicated, and then their signatures and the date that they are signing this document must all be indicated. Don't forget that the lease document, it's a contract. So when they state all these facts in the lease agreement, it means they are giving warranties for which they are bound by. So don't worry about it. All that you need to make sure of is that the recitals contain the fact that it is with the consent and concurrence of the principals or elders of the stool or the family. And then again, make sure that these elders or principals sign the lease document or the instrument. Then
So yes,
you're covered.
yeah, I do understand your point, but I guess it still leaves a bit unanswered, being that if the chief then says, I guess the main takeaway point is to make sure that the drafting covers that. So, for instance, if the chief comes to you and says, I am the only one who needs to approve this, then there has to be something in the drafting that actually acknowledges that the chief has said so, because there's no other way for you to verify. But for you,
Yes.
as an outsider, you have to make sure that the drafting, and this perhaps is also the reason why we must use professionals to actually do some of these transactions.
It is
So
very
that they can
important.
actually pick some of these things out. So yes, I take your point on that. So what sort of interests can families and stools actually grant in terms of land ownership interests?
Well, I would say leasehold. Freehold is out because the Constitution and then the Land Act prescribe the sale of freehold interest in family land or stool land. So freehold interest is out. So presently, the interest that a stool or family can dispose of is the leasehold, the major interest that they can dispose of. I don't know if you want to find out as to why they cannot dispose of freehold.
Yeah, I think it will be interesting to briefly touch on that, because I actually have had a client in the last couple of weeks who has been offered land somewhere in the southern part of Ghana, which appears to be family land. And he hasn't obviously gone to the point of the final document, but his receipt that he's received for the initial payment points to the fact that he's being offered freehold. And so when he passed it on to me, I was like, no, you can't actually have freehold. And then I pointed him to some of the, nuances of buying land now from families and stools. So I guess it would help for you to give us a little bit of a background as to why we no longer sell freehold, and perhaps also touch on if anybody is offered freehold land now, what they should do.
Okay, so before I touch on that, there's something that we need to get clear. Yeah. It doesn't mean that freehold is out of the market. Freehold interest land is out of the market. Individuals who purchase freehold interest prior to the coming into force of the 1992 Constitution still own that, and they have the right to alienate them. Okay, so if you're buying it from such an individual, rest assured that it is a good title that you're buying. But if you're buying it from a stool or a family, please do not go there. It's a no-no. Yeah. Please do not go there. The door is shut on the sale of a freehold interest. And the reason is that land, of course, it's a strike statement that land belongs to the dead, the living, and the generations unborn. All right? So the law would not allow the heads of family, the chiefs or occupants of stool to go ahead and then dissipate land or dispose of land for good, when the living would have to have land, and then the generations yet unborn who will owe allegiance to the stool or the family or be part of the family would need the land. So once you give it away as a freehold interest, it's gone for good. And the law is there to make sure generations unborn and then the living are protected, and then they always have land.
Okay, so it's essentially to make sure that, I guess, the owners of the land don't in the future become paupers on their own land. So now we accept and we know the law requires us or only makes available leasehold land for sale. Can you briefly talk us through what happens when the leases expire?
That is, you mean when the lease expires without, okay, so let me put it this way. A lease could contain a clause, okay, for renewal, right? And then a lease may also contain no clause whatsoever for renewal. So I guess we are looking at a scenario where the lease expires without any clause of renewal clause in it, right? Is that correct?
Good. Yes.
So the law makes provision for that, okay, by way of implied covenants in the lease agreement or the lease document, the instrument. There are three scenarios. If the one who purchased the land is an indigent of the area where the land is situated, okay, then what the law says is that if the lease expires without any clause, without any renewal clause, then the lease automatically renews itself for the period which was indicated in the original lease. So assuming the person had 99-year lease and then it expired, I'm talking about indigent, okay, of the area where the land is situated. If the person had 99 years and it expired without any lease clause, a renewal clause, sorry, then it will renew itself automatically without any intervention whatsoever for another 99 years. In the case of somebody who is not an indigent of the area where the land is situated, it is implied that the lease would have to be renewed, but it doesn't state that it would have to be renewed automatically, meaning that you would have to sit down with the lessor, the person who granted you the land or the interest in the land, and then discuss renewal terms. If you are unable to come to agreement, this matter could be referred to arbitration or any of the alternative dispute resolution mechanisms for it to be resolved. If you still do not come to any agreement, then the matter could be taken to court. But whatever the case may be, it will definitely be renewed. What is not certain will be the term and the other conditions, of course. And then the last scenario has to do with a non-Ghanaian, okay, who, you know, takes a leasehold, and then there's no renewal clause in it. When the lease expires, there is no implied covenant or term for renewal, no. So if you're a non-Ghanaian who is listening to this program at this moment, please take note. If you're buying land, make sure, insist that there's some renewal clause. Other than that, if the lease expires without this renewal clause, the land and whatever is on the land reverts to the stool or the land. So we need to take note of that.
Okay, thank you very much for that. So obviously we know when we're talking about stools and we're talking about skins and we're talking about families, we're also talking about custom. If I do buy land under a stool, a skin, or a family, am I subject to any customary rules, you know, that, you know, the customs and usages of a particular area?
Many years ago, and I'm talking about many years ago, it used to be so. And but the practice now is the stool and then the family. What they do is they charge you an amount. That is the person who is purchasing the land. They charge you an amount in respect of the customary obligations that you would have to perform. So they just put everything in monetary terms for you to pay. And once you pay that, the law recognizes it, that it's evidence of you having performed the customary obligations. So basically, that is the practice now. They charge you, maybe pay 10,000 in lieu of the performance of customary obligations. Once you pay, the law recognizes it.
So I am, you know, something else has come to mind. What about, you know, customary practices like, for instance, curfews, you know, for funerals, as we've had before, or say ban on drumming and dancing in Accra? As such, I presume, and I guess those are well-established practices that when they do happen, everybody has to conform. So those ones are still practices that anybody who buys land is subject to.
As a matter of fact, the fact that assuming that you did not even pay what they call the customary obligations, okay, you did not pay it in cash in lieu of the performance, and then these are not part of the covenants in the lease. I mean, nobody can hold you to observe any curfew or other customary practices, no, unless these are reduced into writing, okay? Because all the implied terms by law are contained in the Land Act. So nobody, if it is not reduced or if it is not included in the lease agreement or the lease document or instrument, then nobody can hold you to it, that you need to observe a more curfew or maybe bring a sheep for the chief to sacrifice and so on and so forth. No, you cannot be held into that.
Well, I think we will have to revisit this question another time. But I take your point. So one major impediment with a lot of and perhaps it's more to southern Ghana and the land of high value is the incidence of land guards. You know, how are these going to be dealt with, or how are these dealt with when it comes to purchase of stool and family lands? Are people protected from these? What is the position of the law or practice?
Well, the new Land Act makes provision for that. And it doesn't matter, it didn't use any of the nomenclatures like land guard, nothing like that was mentioned. But no matter what you call yourself, whether you are the land police, land soldier, land Taliban, or land commando, if you extort money from somebody who has a genuine interest in land, or use violence to prevent the person from having access to his land, or does anything that will prevent the person from developing his rightfully acquired land, then if you are arrested, prosecuted, and then sentenced, you could be spending nothing less than 5 years in prison. So that is what the law provides now. It doesn't end there. It also caters for those who use these land guards. And we know that these land guards are surrogates of people who use them to protect their lands, supposedly. Okay, so if you are behind the hiring of land guards and you are also arrested, charged, prosecuted, you could be spending nothing less than 10 years in prison. So that's what the law provides. But it doesn't end there, okay? The most important thing that we need to note here is enforcement.
Yeah.
The legislators have come out with this provision in the Act to protect their constituents who normally buy land. Okay, so it's up to the law enforcement to now enforce it. If the law enforcement agencies do not have the capacity, if they do not have the resources, or if they are complicit in this so-called land guard issues, then it will become very difficult for this provision in the Land Act to be enforced. And it will just be in writing without any enforcement. So it's important for the law enforcement agencies to really take advantage of this provision and then enforce the law. If somebody reports harassment by a land guard, we expect the police to go and arrest this person, investigate. If the person will have to be taken to court, that must be done.
I think it's a very important point you raise, because my view has been that we do have all the laws. You know, we do have wonderful laws on our books. The problem we have is enforcement. And I don't know if it is about will to enforce or ability to enforce, but it's something that as Ghanaians we have to look at. And as you've said very nicely, the law has been provided, and we have to make sure we use the law to actually make sure that all the bedlam that is around us with land and property, you know, can be helped. So I use that to pivot on to the question of fraud. If, you know, what is the protection available if you know, people are defrauded either by family members or by, you know, chiefs or, you know, middlemen in terms of land sales, which are either multiple or to very, what is the recourse when it comes to that?
Yeah, so for years now, there have been incidents where somebody will go purchase land. You make payment, you take your lease document, you go to the land, and then somebody is there with a club, cutlass, machete, gun, chasing you away, claiming that the same person has sold the land to him or her. And then you're frustrated. You then have to go to chasing for your money, or maybe taking the person on. That is maybe suing the person. But now, in the new Land Act, provision has been made, and it's been criminalized for somebody to engage in multiple sale of land, of the same land. If you sell the same land to 2 or more people, you commit an offense, and you could spend not less than 7 years in jail. Or if you are somebody, you are not a chief, you are not a family head, but even a family member, you do not have any interest in land, okay? You do not have any authority whatsoever to dispose of land, and you go ahead to dispose of the land, you commit an offense, and once you are arrested, prosecuted, you could also end up spending a lot of time in jail. So this is a deterrent to those who engage in these multiple sales and then selling land for which they do not have any interest or title whatsoever. It's a deterrent. But like I say, it's up to us to make sure the law enforcement agencies make sure this is enforced. Other than that, then it only remains in the statutory books, and then nothing can be done about it.
Okay. So there is also recently there's been a lot of conversation, in the news about the fact that the Land Act protects, I wouldn't say, I guess majority would be women, but also men in marriage situations. What are the ownership implications of being married and actually acquiring stool or family land?
Okay, so if you're a married person and you purchase stool land, family land, or indeed any other interest in land from anybody, and you do not have prenuptial with your wife, that prenuptial agreement to the effect that both of you are going to separately own property during the marriage, okay, and then you purchase land whilst you are married. Now the implication is, or what the law provides is that even though in the agreement, the lease document, you may have only your name indicated there, but by construction of law, or in effect, the land is being granted to you or transferred to you, the interest is being transferred to you and your spouse. That must be noted. It is jointly owned by you and then your spouse. So even though you may have gone to the bank to secure the loan, to purchase the land, once you are married, the land belongs to you jointly, belongs to you and your spouse. And for that matter, you cannot deal with the land in any manner without the consent of your spouse, wife or husband. So it's very important. And this is, of course, emanating from the Supreme Court's decision in Mensah and Mensah, with the famous case, which is the 50-50. Equality is equity. So it's important that we understand that. Okay. And I'm pleading with the men especially. That shouldn't deter you from going to purchase land.
Well, what I was going to ask is because it appeared that you are indirectly advising people that before marriages, perhaps they should look at prenuptial agreements. But I guess it is what it is, and we can understand the reasoning behind the law and the fact that it makes it equitable. But individuals would have to advise themselves, as to how they want their marriages to go or how they want their properties to be divided or owned, as you have said. So yeah, I do. I think there are a lot of women now who actually control the purse strings. So it's not so much about men now, because girl child education started a long time ago, and a lot of the ladies now are at par with men. So I think as many men as women are benefiting from this law. But of course, if you're married, you have to be aware of this, and then you have to make sure that you advise yourself accordingly. So there is also this incident where I buy a piece of land, and I've got a client who brought this scenario to me. I think she bought land somewhere in Kumasi, where she paid fully for the land, tried to register and all that. The chief who sold it passed away. A new chief came, and all of a sudden it was like new rules. You need to pay more, or I am not aware of the previous transaction, and almost disclaim that they were aware. And most often than not, this happens when the bank of land that they've got to sell perhaps is diminished. So they come, and then maybe their predecessor has sold everything, and then now they try and use what we call takashi or hinwa, to just come and say, you guys, well, I don't know anything about it. You have to pay us money and all that. I definitely know that is not right. But from the position of the law, how does anybody handle this?
Chiefs will come, chiefs will go, family heads will come, family heads will go. If a chief or family head is removed or passes away, all lands that the person disposed of, for the benefit of the stool or the family, is not invalidated by the coming into office of a new chief or family head. So no chief can assume office, or the stool, occupy the stool, or family head assume office and then request that anybody who purchased land from their predecessors or to bring their documents to regularize them or validate them. No, it doesn't work out that way. The law is very clear on that whatever disposition that was made by their predecessors is valid, and the new chief has no right whatsoever to ask people. Of course, as you rightly said, they harass people just to get more money. And then because people really do not understand the nitty-gritty of land issues and then the interest in land, they go ahead and pay. But you can stand your ground and then be firm on it, that you're not going to part with any city whatsoever, because you've already rightfully acquired the land from that chief's or that head of family's predecessor. And it is not right. These are some of the reasons why the law now, that I'm talking about the Land Act, has a lot of criminal provisions, where if a chief engages in this act, the person could be reported, and then the police would have to pick him up and start the prosecution process. So nobody should be afraid. Once you have rightfully purchased the land from their predecessor, there's no need for you to be afraid of losing your title. Just stand your ground.
Yeah. In listening to you, I think as well it is something that perhaps we don't do enough, and that is coming together. I think that if people know in an area where perhaps there are 100 homes where these chiefs or for new family heads coming to terrorize you or try and force you to pay some money, I think you should come together and perhaps under the umbrella of one lawyer, take the matter to court and fend them off, because we are stronger together. And I think for me, this show, that is why I am passionate about this show. We have to put the information out there so that people are emboldened enough to come together and actually fight some of these things that happen. Too often they are in very little pockets and we deal with them individually and therefore they don't come out. And we all would moan about it, but there's no progress. And I think it's a very good thing that you've mentioned, that people should stand their ground and perhaps they should come together with those other people in the same area who are being pushed around, so that we can get this kind of menace out of the land system once and for all. So in terms of, my last question on this, I guess there are people who are watching or listening who are on the other side. It appears that, we've been hitting so much on the stool landowners or the family landowners. What generally is the advice in terms of managing stool and family land? In terms of progressive stuff that would help them to also, because I think sometimes, to be fair to them, it is because they are not aware of some of these systems. And in fact, before I go to that final question, I think a thought comes to me: vested lands. Now, I have, within the last 2 or 3 weeks, had 3 people come to me who have acquired land and have gone to the Lands Commission to do a search. I have told them that, of course, the search should have been done before the land was acquired. But the reality of the matter is that at this point, they've got documents appearing to be valid for land, but those lands have actually been vested, which means that whoever sold it to them ought not to have been able to sell it to them. So can you quickly just touch on that in terms of chiefs or families selling vested land before I go on to my final question?
Okay, Nana, if land is vested, it creates split ownership, between the state and then the customary landowners, all right? Now, land is vested in the state, or the state takes over the land to manage on behalf of the stool or the family for their benefit. So the state becomes the legal owner of the land, and then the family or the stool or the customary owners become the beneficial owners. The state, once the state acquires the legal ownership of the land, it means they are the ones who can sell the land or do anything with it, manage it, but for the benefit of the beneficial owners.
Yeah.
Okay, so they don't do it out of vacuum, and they are the only ones who can sell the land. It is not right for a vested land to be sold by a family or a stool. That is an illegality. So anything that is done to the contrary, that is having a stool or a family selling vested land, is wrong, palpably. And anybody who goes to the law court to seek redress will definitely succeed. But you see, thank God, and now the law has made provision for a management team to be constituted by the Lands Commission which should comprise the Lands Commission and the pre-vesting owners of the land to together manage the land, so that the sale of it, the disposition of it in whatever means, will be done jointly by them. And as you may be aware, very soon every vested land will be divested per the provisions in the New Land Act, so that we wouldn't have some of these challenges cropping up from time to time.
So I guess the general advice, which I think we gave earlier on, is that you should undertake a search, because for the vested lands, if you went into the middle of a forest somewhere to buy land, of course, you might go to the Lands Commission and there'll be nothing recorded there. But for all vested lands, they have been plotted. And therefore, you should never make the mistake of buying land which you subsequently find out to be vested. As soon as you get your site plan, you must undertake a search. And you would not then get yourself into this bother, because then now it might have to be a negotiation between you and the Lands Commission, and it might be a long drawn. There are a lot of factors that come into what happens to your land if you've acquired vested land outside of the Lands Commission. But anyway, so I move on to my last question, which I was teeing up as an advice to stool land owners or family land owners. What is the best way for management going forward? Because I think, as I was saying, sometimes when you listen to them, it is because the knowledge isn't there, or it is because they don't have the records or the history, and so they actually make some of these mistakes, but not because they're being negligent. Well, I guess you could say they're being negligent because they're not finding the advice or expertise to guide them, but then definitely they're not doing it fraudulently. It's just a matter that they believe they own land and they're selling it. So what, in terms of management, do you think should happen to stool and family lands?
Yes, and it's the proper management. I couldn't have agreed with you more. The proper management of these two family lands definitely would eliminate most of these challenges that people get or have whenever they embark on this tedious process of buying stool or family land. First and foremost, the law requires that stool lands and then family lands must be registered with the Lands Commission, and that's very key. That is something that I expect the Lands Commission and all the other agencies to assist the stools and the families to be able to register the land, that they own, so that will be on record. I know there are challenges because of boundary disputes and what have you, but that is something that we can all work out to make sure these lands are registered. That's number one. And then number two, the Act provides that with the coming into force of the Land Act 2020, it is important for the Lands Commission and then the Office of the Administrator of Stool Lands to collaborate and then assist the various stools and families to set up what the law calls Customary Land Secretariat. And to me, once this is set up, it's going to be a game changer. Why? Because the functions of the Secretariat would be to record their interest in the land. Whatever interest they have in the land within their boundary, they have to record that. And then every transaction that they undertake on the land or in respect of the land must also be recorded. And not just recorded, but at the end of every 3 months, that's at the end of every quarter, they are supposed to furnish the Lands Commission as well as the Office of the Administrator of Stool Lands with records of all sales made of the land within the 3 months. So in essence, what it means is the Lands Commission is going to have a record of all transactions that have been made, land transactions that have been made by the Customary Land Secretariat, And then the Secretariat is also going to keep a copy, so that if somebody goes to the Lands Commission to register an interest in land, the Commission should be able to verify as to whether the instrument is emanating from the Customary Land Secretariat. If it is outside the Secretariat, then it raises red flags, and it's important for them to now investigate further. So this will sieve all the fraudulent deals that people undertake in respect of family and their stool lands. And then the records will help to streamline land transactions and then make it very open, so much so that even people can go to the Customary Land Secretariat to do searches. And then they can proceed further to the Lands Commission to do further searches. And once they get to know that, the search that I did at the Customary Land Secretariat matches with that of the Lands Commission, I'm very certain, perhaps even 100%, that the land that I'm buying it from the right source, and nobody's out there to defraud me. And to me, that is going to be perfect. And that is something that I'm expecting once the regulations come to force. The Lands Commission, as well as the Office of the Administrator of Stool Lands, must indeed collaborate to assist all these stools and families to set up their various secretariat and ensure that the challenges are eliminated by the operation of this secretariat.
Thank you very much. I think you have dealt with that question very well. So we would now move on to our questions, which would come to us. I would make available WhatsApp number. So for those of you who would want to send the messages on WhatsApp, can send them through there. Going through, we have a comment from Latoya Shelton. And I think she is just referring to somebody else to watch the show. Thank you, Latoya. And George Menson as well watching, saying good afternoon. And we have Mohammed Katabar as well, giving us a set of eyes. I have Francis Jijo Cheche saying, where are records of stool and family land leases kept? Mr. Badu, where are records of stool and family land leases kept? And he follows on to say, is it a matter of public record? So perhaps you can take the two together.
Okay, so a typical example, or the shining example that we have in Ghana, is the Otumfuo Land Secretariat. Yeah. Okay, where all stool lands records are kept. And I know that in certain other places, they also keep records, but it is not done well. It is not streamlined. That is the challenge. Of course, they keep some at the Lands Commission and other places, but they also keep records as well. But it is not properly done. That's where the challenge lies. And the reason the new Land Act is making sure that these are formalized, and the Lands Commission, as well as the Administrator of Stool Lands, are supposed to help them really streamline it. You know, we even talk about electronic disposition of land or conveyancing. Once these secretariats are set up, it will be easier for conveyancing to be done electronically. So that is where we are headed now. But for now, some stools have, on their own initiative, set up secretariat that is keeping record of these things. And of course, a number of them too are deposited at the Lands Commission.
Okay. So I guess, Mr. Cheche, the answer is that it exists in parts, but not everywhere. And so I guess I touched on it earlier on as well, where in some places they don't exist. I've had the incident where the situation with a client where land was bought, and the owners who were selling the stool that were selling the land did not know that the land had been sold earlier on in the 70s, because I guess whoever had the records in the 70s didn't pass it on. And so those issues are there. And I guess that is why there's the encouragement for people to use the formal land registration agencies, or as in the Ashanti region, the Ashanti Hines Stool Land Secretariat. So these transactions are recorded somewhere. Jemina to Alabi Isama saying land guards are still disturbing people and taking money. So Mr. Badu, what is your view? I guess it touches on to what we discussed, being that the law has been made, and we pray that the enforcement actually follows through, so that some of these menaces would be a thing of the past. But you know, the incidence of land guards, it's only in certain parts of the country. It's not like it's very widespread, but nonetheless, it's something that has to be dealt with. Francis Jijo Cheche,
so maybe to touch a bit on that.
Okay,
yeah, to touch a bit on that. It's important that the moment you see that a land guard, the so-called land guard, is harassing you, extorting money from you, just report it to the police. I know there could be challenges in that respect, but report it. It is now easier to prosecute them because there is a provision that has been specifically made to kind of take away this menace. Okay, so once you report it to the police is expected to act on it and then prosecute them based on the new provision in the Land Act. You know, gone are the days when we didn't have it specifically, but now
Okay. Hello. So we move on to the next question, which is by Francis Cheche. And he is saying that the enforcers are usually guilty of undermining the laws themselves. And I agree with him that sometimes that is the problem. What is your view, Mr. Badu?
Yeah, I totally agree with him because in my submission, I mentioned that some of the law enforcement agencies themselves are complicit in this land gas situation or menace. So sometimes it's quite difficult for people to get justice when they are being harassed or monies are being extorted from them by this land gas. But well, it's up to all of us to rise up and make sure that those that we pay taxes to, sitting up and then doing what is required of them. Other than that, then we'll still be in a limbo.
Yeah, I agree with you perfectly. So the next question, and unfortunately we've lost Mr. Badu, but we can still have his voice feed. The next question is from Evans Osei, who's saying, how do you make a claim on a land belonging to a parent who died intestate without evidence of death certificate? Mr. Badu?
Now, can you ask the question again?
How do you make a claim on land belonging to a parent who died intestate without evidence of death certificate?
Without evidence of death certificate?
Yes.
Well, there are processes that you need to follow. If you don't have the land certificate, the death certificate, what could be the reason? Could it be that the person disappeared and you don't know whether the person is alive or not? Then the law makes provision that after 7 years or so, it could be presumed dead. But assuming the person was already buried and no death certificate was acquired or whatever, there could be witnesses. You could do an affidavit and others and then follow through the procedure to obtain letters of credit and then what do you call it? Go for the land. That is if you were a beneficiary. The beneficiary here meaning you are either the child of the deceased. You're talking about the person having died intestate. Whether you are the child of the deceased, the spouse, or maybe part of the extended family. So basically, that is the process that you need to follow.
Okay. So our next question is from Francis Otu. And he is saying that enforcement is very critical. The court processes should also be considered. That is cost and time. Yes, I agree with him as well, because I think it's good we have the law, but we also have to make sure that the entire machinery that works around this also works and works efficiently. What is your view, Mr. Badu?
Yeah, I could also help agreeing more with you. The challenge always has to do with enforcement. Like you rightly said, we have beautiful laws on our statute books, but the challenge is enforcement. They are there. How do we enforce it? Remember, we're talking about if a chief double sale of land, the person commits an offense and could be prosecuted and imprisoned. Which chief are we talking about? Some of these chiefs are very powerful. Which chiefs are already actually if this person is doing it? So, likely the law enforcement agency will just overlook it, and then people continue to suffer. But nobody's about the law. Was it Norway or so when recently the Prime Minister was arrested, was fined or so for breaching COVID rules? Nobody's about the law. Until we come to this realization, then the laws will just remain on our statute books and they cannot be enforced.
Yeah. Okay. Nite Kotego says kudos. And then I have George Mensah saying, can we have a link to the new Land Act? Mr. Mensah, if you do send me your email address, either through our WhatsApp or through our email address, I would send you the new Land Act. Kingsley Amprechum is saying, is there a difference between farmlands and land for building? Mr. Badu?
Yeah.
So Mr. Amprechum is asking if there's a difference between farmland and land for building.
Oh, you say also very important, but we are talking about the bare land. So once you purchase it and you agree as to the use that you're going to put it to, which of course should be captured in the lease document, then you're good to go. There's really not much difference. Perhaps the difference would have to come about when, depending on the zoning.
Yeah.
Okay, the area is zoned for say residential or for commercial, and so on and so forth. Then you have to abide by it. Okay. You cannot use an area which is zoned for say residential. You cannot use it for farming.
Okay.
Likewise, you can use an area which has been zoned for commercial, for residential. So these are the things that we need to look at for.
Okay. So I think Mr. Amprechum goes on to ask another question, which I would help him with. And I think in the last show, when we dealt with leaseholds, we touched on that in terms of uses. So his follow-up question is, if I own farmland, can I build on it without recourse to any chief? Now, if the user clause in that lease agreement that you've got allows you to farm or says it's restricted to farm, then within the extension of the law or legal interpretation, you can build, for instance, a farmhouse in which your tractors and whatever or something, but you can't build a hotel, for instance. So you can't build on it, but so long as whatever you're building is, as you say, is an attachment to the use that you've been given in terms of being a farmland, then you're fine. Eunice Fenting says very educative. Thank you very much. We've got Francis Cheche saying, would it be ideal for land in areas of Ghana where we have a lot of land issues to be vested? That's a loaded one. I think the lands that were vested themselves, there were questions about how they've been managed to this date. And therefore, I guess it might be a thought, but as always, it comes to the proof, how we actually end up doing it. It's a good idea, but how we end up doing it is the issue. Mr. Badu, do you have something to add?
Yes, definitely. As we indicated
Mute this before. Is it okay now?
Yes.
Okay. So as we indicated, the rationale for vesting land had to do with the challenges that people were having dealing with the land themselves. That's why these lands were vested in the state for the state to manage or hold in trust for the people. But now we also realize that if investing it still creates challenges. You mentioned rightly that we're still selling vested lands to people. And the law realizes that, or maybe the state realizes that there's no need for the state to get into that. So even those that have been vested in the state, they are going to be divested. So there's no way any land is going to be vested in the state anymore.
Okay. So I have a question from Papa Toro saying, very interesting. Are the chiefs aware of this legislation and the enforcement?
Well, it's up to them to know, because ignorance of the law is no excuse. So it's up to the chiefs to make sure they really understand the provisions of this the law. That's the New Land Act. So no chief can do double sale and then say, oh, I didn't know that now the law has prescribed this practice. No, the law will still deal with them.
I guess we should also be ambassadors, and that's why we've got a show like this where, we should pass on. I have had conversations with landowners where they've actually argued with me why they can't sell freehold, and I found it very interesting. But I was trying to advise them and tell them what the law was and perhaps the advantages of not selling freehold, but they didn't want to have any of it. So we have a problem. But that is why we have a show like this, which would help to actually get the information across and for us all be informed. Mr. Amprechum is asking if the Land Act has been assented to by the President. Yes, the date on the Act is actually the 23rd of December, 2020. So it's law, and we all have to abide by it. Nite Kotego, Phobia, he's saying, great show. Thank you. Mary Apia Ishan says Lands Commission. I don't know what she is trying to allude to. We have Redeemer S. Akui saying very educative. Thank you. Kingsley and Pretum, again, any education on how chiefs would be held accountable for land sold in their jurisdiction? Would auditors audit such accounts? Would they be required to issue GCRs or official receipts to buyers? Mr. Badu.
Yes, chiefs, the law makes provision for chiefs to account for all the transactions that they undertake in land. And as a matter of fact, don't forget that the land does not belong to the chief, neither does it belong to the head of family. They are only caretakers. They are holding it or managing it in trust for the members of the stool or the family. So whatever sale that they undertake, they must account for it. All the rent and then other payments that are made to them through the office of the administrator of stool lands, the lands commission, all of it must be accounted for. And provision has been made to ensure that indeed all transactions that are undertaken by the chiefs and the heads of family are accounted for. You know, the challenge is people do not insist on this accountability, right? So the chiefs now assume that indeed, once you are installed or skinned as a chief, or once you are selected or elected as a head of family, yes, like the land belongs to me because all the money comes to them. And then nobody comes to them to say, what did you use this money for? But as a matter of fact, it's supposed to be for the benefit of the members of the stool or the family. And I must commend some of the chiefs who have established scholarship schemes and others to ensure that their subjects or members of the stool benefit directly or indirectly. But those who are buying 8 V8 cars and 10 Pajaros and what have you, the law will catch up with them because they must account. One day, the law will catch up with them and they'll have to account for what they use the money for.
Okay. Francis Chijo Cheche is asking, would all these records be kept in a digital form?
Could you clarify which records?
Well, so I guess the records from purchases or transactions with families or stools in relation to land. I guess because that's where we are now.
Yeah, definitely. With the establishment of the Customary Land Secretariat, we expect that all these records will be electronically kept as well. And I mentioned that the Land Act makes provision for electronic conveyancing. And this will help it a lot, where all these records are electronically kept. And once you go do a search, it should be very easy for you. Perhaps even for the fact that you need to go to them to make some payment before the search is done for you, you could even sit in the comfort of your home. And after making a Momo payment, that mobile money payment, or using Visa to make payment, you could just have a passcode or something to check certain records and be sure of the record that you need or the information that you need from the Customary Land Secretariat. So definitely they'll be kept in electronic form.
Okay, so we have Mary Shen saying, thanks for this, very educational. Then Perpetual Asumeni says, Bawis Stool also has a good Customary Land Secretariat. So I guess it's kudos to the Bawis Stool. And I think we have to encourage a lot of the landowning families or stools to follow suit so we can sanitize the system. Francis Cheche is saying, does the new Land Act make provision for records to be kept digitally? I think you've answered that in terms of the move towards electronic conveyance, and I guess that follows through from there. Konstantin Doku says some of the police are more than the land guards themselves by their posture. Well, that made me laugh. But yes, Konstantin, I think it's very true, and by education and by us being out there and letting people know we know our rights and bunching up together, forming groups, we would have this thing dealt with. I think too often we fight it individually, and that's why we never succeed, and we always complain about it. But I very well agree with you, Mr. Badu. What view do you have? The posture of the policemen and land guards.
Oh, she's absolutely right. In certain cases, they themselves are the land guards, because maybe a big politician, a big shot somewhere has land that he used connivance and other means to acquire, and he wants to protect. Yeah. And because he has access to these security personnel, he uses them as land guards. Those who are supposed to enforce the law are now being used as land guards. So where do we go from there? And this is where we need to really rise up, because we pay the taxes. We give them the money to do what they're supposed to do for us. We need to ensure that they are accountable for what they are supposed to do to protect us from purchasing land and purchasing it peacefully.
Okay, so Eunice Fenting is saying, have the land guards been informed to make aware of this new land act? I guess, Eunice, we don't even know. Nobody would own up to be a land guard in this day. So, but as Mr. Badu said previously, ignorance of the law is not an excuse. So they should advise themselves. Or if you do have anyone whom you know who is either threatening somebody or threatening yourself, then perhaps you should bring the law to their attention. Perpetual Smeni is saying, great discussion. Edinkra Photography is saying, thank you, enjoying every bit of it. Go Chelsea. Well, that was a good win today, but we'll talk about that another time. Perpetual again is saying, kudos, Nana and Stephen. Jemina to Alabi Isama is saying, good question at Eunice. Eunice Fenting again is saying, it will be proper for the Lands Commission to educate the land guards on the new Land Act. I agree, but I guess who would own up to be a land guard to be educated? I guess that's where the problem is.
We can organize a seminar for them.
A seminar for land guard. So whoever turns up is a land guard. Well, you know, I guess back in the while in university, we used to call ourselves land economy students as land guards. So perhaps we can double as executive land guards and attend that. But Eunice, I get your point.
Nana, on a more serious note.
Yeah.
On a more serious note, Eunice, is it Eunice who asked the question or made a comment?
Yes. Yeah.
Yeah, she's right. It's important. This provision in the Act should not be silent, okay? Even though I mentioned earlier that ignorance of the law is no excuse. But it's important. Knowledge of the provision of the law could serve as a deterrent. Yeah. If the person is not aware that, hey, there's a provision in the Land Act now that if I continue to do what I'm doing, I could end up in Isawam or any of the prisons for a very long time. So let me find a better job to do and then abandon this land guard business. Yeah, so I'm expecting the Lands Commission, maybe the ministry itself, to embark on education on the radio stations, on television and other channels to educate people. And definitely we are going to have the land guards and others also listening in. And once they get to know that, of course, there's a provision in the Act that really prescribe their actions, they will advise themselves. It's important as well.
I think it's also, you know, to add on to what you say, to make an example of one or two of them, you know, and to let everybody know that if we get any, you know, just because it's setting the example, making people aware that these laws will be enforced is also very important beyond the education. I go on to Constantine Doku. He says, please, how and where do we get the new Land Act? You can get it at Ghana Publishing, I think, which is near Accra Polytechnic. But I do have a... Sorry? Accra Technical University. Okay, my apologies. Accra Technical University. Or if you do send me your email through our WhatsApp number, I can send you the electronic copy that is floating around. ED7115 is saying very informative, thanks. Frimpong, we say land guard issues has come to stay. No government can do anything about it, period. Well, I guess we can understand the resignation to the fact, but I think I would rather have a more positive outlook of it and hope that there will be change, because we can't possibly be proceeding the way we have been proceeding. And so, yeah, I see your point, but perhaps let's hope that things will change with this new act and some enforcement. Mr. Badu.
Yeah, I understand the position of Yao. He's been pessimistic because for a long time now, the land guard issue has been a major issue in the country. It's being talked about all the time, but nothing has been done about it. So perhaps that's why he's having this pessimistic thoughts. But let's also be a bit optimistic and then ensure it's about you and I. Nobody's going to make sure they enforce it, but you and I. We need to rise up. But that's why we're having this educative program. Who knows whom it will reach out to. It's important once you go on radio, you pick the phone to make a phone call to the radio stations, hammer on it. So we cannot sit back, fold our arms, and then say, oh, we cannot do anything about it. There are a lot of things that we can do to really stop this land grab menace.
Okay, then I will swap to WhatsApp because I've got some messages from WhatsApp. I have a number here, somebody saying they are watching, but I don't have the name. The next question is there a limit on how much advance rent you can collect when leasing a place? What happens if you collect higher than the limit? And when does it go into effect? So, Mr. Badu, that's one for you. Not strictly aligned to our question, but our topic for today. But if you can answer that for me, please.
It's always a difficult question because the laws are there, okay, yeah. Even as to the number of years that you can pay your rent by way of advance, okay. Instead of the 2 years, it's far lesser than that. But they don't work, and there's no way they're going to work when demand for land far outstrips the supply. Sorry, I'd say land accommodation outstrips supply. So you see, you don't have a choice because if you don't want it, somebody else is picking it. So the laws are there, all right. They are not to take advance for a certain number of months, but they are still taking in excess of even 3 years. And you either take it or leave it because it's about the economic play of supply and demand. And until they come into equilibrium, that is supply meeting demand, forget it. The laws regarding tenancy and rent will not work in this country.
Okay, thank you very much for that. The next question, I've got the next question. My name is Ifwa. What happens if a piece of land not belonging to, I can't see the word there, but not belonging to an individual is sold illegally? So I presume that the scenario is that somebody who doesn't own land sells it. What happens if somebody sells land that they don't own?
The person, under the new Land Act, the person commits a crime. The person commits a crime, and once he or she is arrested, he could go to jail for quite a number of years. Minimum, I think, 7 or 5 years. So that person definitely commits a crime, and all that you have to do is to report the person to the police and make a statement.
Okay, so I have Mrs. Rhoda Techi and Kofi Techi sending us a message saying that they are watching us. Thank you very much for watching us and this show. We hope that you carry on the message. I have a plot of land that I inherited, but the family heads are demanding a fee of 20,000 Ghana cedis for an expenses made by an encroacher who happens to be a family member as compensation to the encroacher after destroying my foundation, please. My name is Nana from Ablekuma. Please, can I have your contacts with the land? Okay. So I guess this is one of, I don't know the forces that are at play in this case, but it's a point we touched on, being that the family land has been sold. The family seems to be extracting some money from somebody who already owns the land, according to what we are having, and they have destroyed their foundation. So what would be your advice?
Well, we don't have all the facts surrounding this case. Perhaps he would have to contact us because it's not too clear-cut.
What? Okay. So, Nana, I have your email here. I would send you the details for Mr. Badu, and then I guess after this show, you can contact him and have a discussion. Because many a times, even though we have discussed these things generally, there are specific issues that must be appreciated if we have to give you good advice. So I come back to Facebook and YouTube, and we have Mr. Amprechum asking, does a new Land Act require an LI to operate? No, it's actually in force. There might be parts of it that would require the minister or some other body to make other subsidiary legislation, but the whole act is actually in force. FBL says, thank you. What happens if caretaker family head doesn't account for it and another descendant seeks to reclaim the land from the purchaser? Where does the purchaser stand, please? So, Mr. Badu.
Now, can you ask the question again, please?
So it says, what happens if a caretaker family head doesn't account for it and another descendant seeks to reclaim the land from the purchaser?
What you can do is to take the person to court.
Okay.
The law allows you to take the caretaker head of family to court if the person doesn't account for the land that he or she is selling. So that is it. You can go to court and then seek redress as a family member, but you have to be a family member before you can do that.
Okay. I think he is talking more about somebody who has purchased the land.
Somebody who has purchased the land.
Yes. So I think we discussed this earlier on, being that, a predecessor granted the land and then a new person comes in and he's saying, well, I'm the new kid on the block. I'm charging you something. He's asking where the purchaser stands. But I think you have previously advised that they do not have to be bullied at all.
No, not at all.
Yeah.
Yeah.
Okay.
Not at all.
So
I mean, you have to stand your ground. Unless the land was fraudulently sold to you, okay?
Yeah.
And we know that in law, fraud vitiates everything. But once it was properly sold to you by the predecessor, there's no way somebody can bully you to take more money from you as a purchaser. Stand your ground. The law protects you.
Okay. Following through from this question that has come, I think there is also a unique problem that we have, which we may not be looking at properly, being part payment for land. And yesterday I was thinking through having a program discussing that. A lot of people go to the land and pay maybe 50%. For those who can afford it, they almost pay everything before they have any documents. Now, assuming that you paid this to Chief A and Chief A dies tomorrow, maybe he's giving you receipts, you haven't got the lease document, and then Chief B comes in saying, well, I don't know anything. You dealt with Chief A. You're actually caught in the middle. Elsewhere, as soon as you part money, there must be a basis for parting the money, and there must be a valid legal agreement that ties you with whoever you're giving the money to. But so often, because we are so keen and eager to get land, you go there and the first thing is pay 10% or pay 50%, and then you pay. And you don't actually get any legal document. You don't get an agreement for a lease or something that binds you with the person who is taking the money from you. And so I guess you would agree with me that if it so happens that you have paid money to somebody who has passed on and that person didn't give you something conclusive, it might become problematic. Yes, the courts, depending on the evidence that you have, may perfect or may complete the process for you. But it can be tricky if you're caught in that scenario. What do you think?
Okay, let me come in here. Once you make part payment, okay, you own equitable interest in the land, not legal interest, okay? But you have equitable interest in the land. Now the next question is evidence. What evidence do you have to show that you made that part payment, okay, to the new chief or the new head of family? That is the question. So it's important that once you make that payment, even if a lease document has not been signed and given to you, insist on receipt. That is very key. Insist on receipt. Receipt that has been given to you in the name of the stool or the family. Take that one and then keep it. That is evidence enough to show that you have equitable interest in that land. And then whoever comes in to succeed the head of family or the chief who disposed of the land to you, you just have to show that evidence and then finish paying up to him in order to fully own the land, and then maybe take the process or start the process of acquiring legal title to that land. Now, in the absence of, say, a receipt, could you also be able to provide evidence in respect of witnesses who were there when we were making the payment? It could be witnesses who were part of the family. You made a payment to the head of family, to the chief, and the elders were there. And if the elders can really testify that indeed they were there when you made that payment, and this was the amount that you paid, that is also good evidence, oral evidence, to prove that indeed you have equitable interest in that land. And the person cannot just wave you off. I'm talking about the new chief or the new head of family cannot just wave you off because you cannot produce any other form of evidence which to him is satisfactory.
Okay, so the next question we have is from Ed7115, and he says, can you elaborate on the point about indigenes having the right to automatic lease renewal? So, Mr. Badu.
Okay, so I just want to use an illustration. Can you give me any stool name? Say Osu. Okay.
Okay, I was going to give you Togbi Anachu of Golokwati.
Okay, so you belong to the Osu stool. Okay, and then a land in Osu has been given to you by way of, or you are an indigene of Osu, and you've been given a lease. But in the lease, nothing was specified that it was being given to. No, it was specified that it is being given to you for 99 years, but nothing was indicated that at the end of the 99 years, your successors would have to renew it for further 45 years or further 99 years. Nothing like that was indicated. The law says that once you are an indigene of Osu, per this example, you don't need to worry about it. But by virtue of you being an indigene of where the land is situated, that is Osu, then the lease would automatically renew itself without the intervention of anybody whatsoever. And it renews itself using the original lease term, which was the 99 years. So in essence, you have another 99 years.
Okay.
Lease renewal. I don't know if that makes sense to the one who has the question.
I think that
so
answers
you don't need to now sit down with anybody to discuss new terms whatsoever, but automatically it is renewed once you're an indigene of the land, of the place where the land is situated. That is what the law says.
I guess what we used to call a lacuna in the law perhaps would be what the actual terms are. But then also it would be very interesting to note what happens if the indigene now then sells the land on in say year 90 to somebody who is not an indigene. Then I guess there will be some complications, but it's not for today. I just think
no, there wouldn't be any complication whatsoever. If at the end of 90 years, it was assigned, it was leased to this indigene for 99 years, and say after 50 years, 70 years, he also sublets it or assigns it to somebody else who is not an indigene. Okay, so it means that the second scenario or applies. Land which is a lease which has been given to somebody who is not an indigene. So there's implied renewal, but this time not automatic.
Yeah.
Because you are not an indigene, there's an implied renewal in it, but it is not automatic. You would now have to then sit down with the hairdresser and then discuss the new terms. Say, I'm giving it to you for further 25 years on these terms and conditions. And then it will be renewed for you.
All right. So we have Daidi Divon saying LOL at TT. I do not know what that refers to, but thank you for your comment nonetheless. Papa Toro saying it's worth knowing that the Ghana Police has a land dispute unit. And yes, thank you very much for bringing that on. I think they have a land dispute unit at the headquarters, which people can actually avail themselves to if they have any issues. Daidi Divon again say, well done guys for another insightful topic. Thank you, Daidi. We have Ivan Sosei, with only an indenture, site plan, receipts from the original sale of land, a search report from Lands Commission in my name. Am I the legitimate owner till the land title process is complete? Mr. Badu.
What was the last portion?
So let me read it again. It says, with only an indenture, site plan, receipts from the original sale of the land, a search report from Lands Commission in my name, am I the legitimate owner till the land title process is complete?
No. You see, once you have the lease with the receipt, with the site plan, it's only conveyance that has been done for you. Transfer of interest that has been done for you. Until it is registered, you don't have the legal title. Okay. You only have equitable interest in the land. So you are not the owner. When we say owner, in that we are talking about legal owner. I don't know if that is not too clear. We are talking about, we have legal ownership and equitable ownership. So once these have been given to you, it is up to you to now send it to Lands Commission to start the registration process. And until the land certificate is issued to you, you are not the legal owner of the land. Okay, the legal ownership still rests or is still vested with the one who sold it to you. But because you have parted money and the land has been transferred to you, you own, you have the equitable interest in that land. You can go ahead and do whatever that you want to do with the land. Until you obtain the land certificate, you don't have the legal title.
Okay. So we have Constantine Doku saying that they have changed their names from Land Guards to Asafu Group in disguise. So, Mr. Badu, if you don't know, Constantine is informing us that now the Land Guards are called Asafu Groups. So we have to watch them. And I guess that's the difficulty in inviting them for a discussion. But perhaps as Asafu Groups, it will be possible to invite them as Asafu Groups, but not Land Guards.
If you recall, I mentioned that the Land Act doesn't mention any name. It doesn't use any of the nomenclatures, like Land Guard, Land Commando, Asafu, or whatever. It doesn't care about that. It is about what you do, your acts, which will determine whether you have committed a crime as a land guard or whatever. It is what you do. If you go harassing people, if you go extorting money from people, if you go preventing people from having access to their land, you have committed an offense. Whether you call yourself Asafu, whether you call yourself a land commando or land Taliban, it doesn't matter. You've committed the offense, and that is what matters most. And you'll be prosecuted, and if the evidence suggests it, you'll be jailed as well.
Okay. I've got Eunice Fenting is saying, thanks for a great discussion. I'm satisfied with the answers. Constantine has sent her number. And then Yafrim Point is saying, land guards are taking digging fees, roofing fees, painting fees, relocating fees, etc. We're really tired. I guess, we share in your frustration, and perhaps the little advice that we can give to ourselves is that we have to come together to fight this menace. We have to, kind of perhaps have a central platform where these things will be put out there for us to be able to know and then get some sort of solutions towards them. Mr. Badu, I don't know if you have anything to say.
Yes, we are all suffering it. You've rightfully acquired the land from the stool or the family. You send your workers to the land to start development. And then you are in the office, you are in the market, you are somewhere, they give you a call that the land guards are here demanding for digging fee. They've taken the tools, the construction tools away. These are worrisome acts that are always being perpetuated on us. And we need to ensure the enforcement of this provision in the Act to make sure that we all have a peace of mind whenever we buy land from the stool or from the family.
Okay. So we have Eunice Fenting is saying, thanks, Jemina too. Ivan Sosei is saying, can you please talk about adverse possession in case of squatters? Evans, it is a topic that I know is very hot at this moment. I am actually trying to put something together. Perhaps I'll bring it on in one of my subsequent shows. It's too broad an area to deal with in just this question and answer session here. And I think I would want to go into it in depth. So thank you for your question, but we will try and make a whole show on that.
If I can briefly touch on that. The adverse possession in respect of squatters.
Yeah.
Okay. I don't know what the definition of squatters to him is. If you have a land, a vacant land, and then say you bring somebody there, all right? We call them caretakers.
Yeah.
All right. To come and then occupy the land and take care of it for you. That person is not a squatter, and that person cannot claim adverse possession. All right. And if you have a bare land, you just bought the land, you fence it, and then you travel to the UK, you travel to the US, thinking that the land will be there for you. And then somebody occupies the land without your knowledge.
Don't take on the bogus, please. It could be that they traveled from Accra to Kumasi.
No, Accra to Kumasi, they always come back and check on the land.
Okay, then.
Yeah, so it's important. If the person traveled, assuming, or even if you're in Ghana and then you've just neglected the land, you never visit the land, and then somebody goes into possession. That is not build a one-room house and then is living in it, having a backyard garden. And you don't visit the land to eject this person or assert your possession or ownership of the land for a period of 12 years. If you go to sleep for a period of 12 years, then you lose the land. Even if you've registered it, you lose it, unless it is a public land. If it is a public land, then adverse possession doesn't affect it anymore. But if it is the land that is being given to you by the stool or family, and then you don't do anything about it, then definitely the land could be taken up or taken over by somebody who possesses it for a period of 12 years without any disturbance whatsoever from you. The person takes it.
Okay. So next question is from Raf Dina. With the automatic renewal, do you have to pay up something, or you just continue to pay the peppercorn rent, Mr. Badu?
Exactly. That's the answer is yes.
Okay. And then we have Joe Mensah say, kindly share the link for the act, please. Mr. Mensah, if you send us a WhatsApp message with your email, I will do my best to send you the act. FBL, thank you. What's the position if seller did not register their title before disposing of land to go to others on part payment basis, please? So I guess the seller is selling, but the seller themselves have not registered their title. What is the position?
Okay, so the seller didn't have a legal title. So what he sold to you is equitable interest in the land. So you can pick it and then register it yourself.
Yeah. Okay. So
equitable interest is also interest in land.
Okay. We have Yalfrin Pong. Please let's use Botiano as a case study. And then he's come back again at the bottom to say Botiano lands. I guess we don't have any specific knowledge of Botiano lands or issues there. So if there's any question you have on Botiano lands, perhaps we could assist you with it. But we haven't prepared for anything on Botiano specifically. Collins Ni Anang Opoti is saying, great discussion. Can I get a copy of the new Land Act? Yes, please. Do WhatsApp us with your email address and I'll send you a copy of the act. Nathan Boss Ose is, what is the best thing to do if another party has fraudulently registered a land ahead of you when you are still in the process of registration of the land? So somebody beats you to the line.
Maybe I can give a scenario of the double sale. Somebody sold the land, say a family or school sold the land to you. And then before you could start your process, they've sold the land to another person. And that person has gone ahead of you to start the registration process. Of course, there wouldn't be any record of you at the Lands Commission. So the Lands Commission will just assume that this is the person to whom the land has rightfully been disposed of to. And they will go ahead and register. So you'll be late. Unless we don't want to go into the technicalities as to equitable interest versus legal interest. Okay, yeah. But when the person gets a legal title, it will surpass your equitable interest, and the person can exercise ownership of the land. So it's important that once the lease document has been given to you, you start the registration process. Very important. Don't wait.
So Raf Dina is saying, I assume the yes is for peppercorn rent, and that was the renewal. And I guess I am slightly of a different opinion with the rent on renewal, because it doesn't appear that the law is actually specific. It just says you can renew for 99 years. And I think it is something that perhaps somebody may have to test the law at a point to find out, because if you're the landowner and then the law allows you to renew, I would say, yes, fine, I give you that right to renew. But you can't tell me that after 99 years, you're renewing on the same terms as I had 99 years prior. So I guess that is what Rafik is alluding to. And I haven't seen clearly in the law references to the fact that the terms of the previous lease would be passed on, except for references to the length of the lease, prior lease. So if you have a 99 years, the law allows you to get another 99 years. But the law doesn't seem to say that it will be on the same terms, or so that you pay the same rent for the next 99 years. Because obviously at that point, it is a bigger investment, so it's a bigger interest. You would have developed it, and technically, and if it's law, we can't challenge it. But I can see the landlords actually being up in arms if that is the interpretation to it.
Well, we call it for time value of money. Definitely after 99 years, if the person paid, say, 100,000 Ghana cedis by way of consideration, okay, you don't expect the person to pay upon renewal, whether it's automatic or negotiated, to pay the same 100,000. And that will be part of the terms and conditions of the lease. That, of course, at the end of the period, you would have to negotiate for yes, for a new consideration. Okay. All right. So it wouldn't be like maybe you are paying, you've been paying 5 cedis all this number of years and you still pay 5 Ghana cedis. No. But the focus, as you rightly said, is rather on the length.
Yeah.
On the length of the leasehold.
Okay. So that's the question for Mr. Duon. I've had another comment on WhatsApp which says, I think it's Ifwa who came back. Okay, I think that is lost. So we have a comment from Nanaje who says, great discussion, thanks. Constantine Doku says, please, I would be glad if you could share the WhatsApp number, where to send our emails, WhatsApp number. Great program, thank you. Constantine, the WhatsApp number is scrolling at the bottom of the screen. So, but just to repeat it, is +233 5000 600 Joe Mensa says, you say without disturbance for 12 years. If you visit your land regularly and have occupiers live there at your discretion on goodwill, is your land at risk of adverse possession? So you see why I wanted to treat this on its own, because it's a topic that we all know is buzzing now, and I guess we would have to actually prepare properly and make sure that people are properly advised. A lot of these things, it's difficult to give advice without actually knowing the specific facts of this and the circumstances surrounding this. But I will throw it back to you, Mr. Badu.
Okay, so let me clarify. If you were the one who gave permission for the person to live on the land, that is not adverse possession. We call it license. License simply means you've given permission for somebody to live on your land. And that person, even after 20 years, cannot wake up one day and then say, oh, adverse possession, the land now belongs to me. No, you gave the person permission to live on it. Adverse possession is when, without your knowledge, because you have not been visiting your land, because you have neglected your land, somebody occupies the land. Nobody ever comes to make a claim on that land for 12 continuous years. Nobody disturbed it. Then the person could claim adverse possession. But if you were the one who granted them permission, what we normally call caretakers, to live on the land, weed, and then keep the land in good shape, then the adverse possession doesn't come in at all. That is license. You've given the person permission to live on your land, and that person can never claim it.
Okay. So I have a comment here from Joe Mensah saying you're doing a fantastic job educating us. Thank you, Mr. Mensah. And then I think our last comment, because we have been on for a long time, would come from Nanaje, who says, does the traditional authority which sells land to you have the right to come back to claim with reasons, with the reason of you not having developed it within a certain period? So I guess, yes, that's also another thing that's happening, yes.
It's always an interesting question. People think that it's implied. It is implied that once land has been granted to you by family or stool, and you don't develop it within 2 years, the stool or the family could reoccupy the land or take it away from you. It's a fallacy. It's a misleading thing that has been peddled around for some time now. That is not true. Unless it is expressly stated in the lease that if you do not do anything to show ownership or possession of the land for a period of 2 years, then the land will revert to the stool or the family. Then it's an agreement. Don't forget that the lease document or the lease instrument, it's an agreement. It's a contract between you and then the grantor, which is either the stool or the family. So if they state it expressly in that lease that if after 2 years you haven't done anything to show ownership or possession of the land, then the land will refer to the stool or the family. Then that is it. The two of you sign up on that. And once you don't do it, then they have every right to take the land back. But if it is not in their agreement, then there's no way anybody can take the land away from you after 2 years of having done nothing on it.
Okay. Is there nothing in the Local Government Act? I think I recall some references to, but I wouldn't pin you on that as to that. But thank you very much for your response. I've got another. So I've got a message on WhatsApp with email. Could you please send me a copy of the New Land Act? Okay, I've got that. So our last question would come from, how do I contact you both directly for further discussion, please? From Nathan Boss or say, please do send me a WhatsApp message on +233 5,673, and we would I'll put you in touch with Mr. Badu, or I will deal with whatever queries you do have. Our email is also info@landpropertyfocus.com. And you can also send us messages on Facebook or through YouTube if those are better for you. So, Mr. Badu, I have exhausted all the questions that we've had. I think we've been on for more than an hour and a half. I can only thank you for your very thoughtful responses and how you've helped us to educate, for us all to be educated as to these matters when it comes to land and property in Ghana. You definitely would come back someday. I think there's adverse possession floating somewhere there for us to discuss. So thank you very much. And for everyone of you who have watched us today, thank you as well. And as well, my executive producer, Kwame Ajay, who is watching, thank you very much for all the support with this program. Without you, I don't think we would have been able to bring this wonderful show to the benefit of Ghanaians. So thank you very much for watching. As I said at the beginning of the show, please follow our Facebook page and do like the Facebook page as well. If you have access to YouTube, please do subscribe to the channel. And you can also register on our website, which is landpropertyfocus.com, where we would send you advance notices of our programs and when we do a summary. So after this show, we would have a summary which would capture some of the salient parts of the discussion. And so if you do subscribe on our website, we're able to send you that information. And we very much appreciate your support and hope that you have been educated and found this particular program and topic helpful. Thank you very much for joining us once again.